Okay, Cary, today we are going to talk about Florida's 5-year look back rule. Really, what every caregiver needs to know in Florida about this. Can you start out by painting a picture for our listeners? What does it actually look like when a family gets blindsided by the Medicaid look back rule? What is the most common situation or scenario that you see?
I think there's a lot of confusion out there when I see clients about what this look back rule is, and how it applies. And so they've maybe have talked to other friends and family, and they've kind of created in their mind what the rule is, and they come up with different solutions on their own on how to try to avoid this. So, as far as typical scenarios that I see, I think in a married couple situation, they often will transfer all of their joint assets to the healthier spouse, thinking that they're getting ahead of that 5-year look back. The problem is that when we apply for Medicaid for one spouse, they look at the assets of the couple. It doesn't matter if it's in the wife's name, the husband's name, the joint name. So they thought they were doing something to kind of get ahead of it, but in fact, it really had no effect on the overall plan and the application at that time. For my single clients, the common scenario is that they will transfer assets to their kids, trying to get ahead of that 5-year look back. The problem is that they don't realize the risk that they're subjecting their assets to, because if they transfer it, let's say I transfer my assets to my two kids, and one of my kids is a spendthrift and starts spending all of it, and my other child is, potentially going through a divorce. Now we're subjecting my assets to their risk.
Mm.
And so they really create more complications, because they just didn't have the knowledge and they had a misunderstanding of what that 5-year look back is.
Walk us through the specifics of what exactly Medicaid is looking back at. Is it everything? Is it all assets? You mentioned like either tithing, or is it just certain transfers?
They're really looking from a technical standpoint, they're looking at any and all transfers, and they kind of highlights, within their Medicaid manual themselves to tell their caseworkers, "Hey, be on the lookout for these types of things." If they see, larger transfers, we tend to say, "Hey, if we see anything over $1,000 in the bank accounts that are being, you know, either withdrawals or transfers, we're gonna
Mhm.
question those because, likely that Medicaid is gonna transfer those." If there's been a purchase of an annuity, that can create a transfer. If there's been any kind of an addition of individuals that you put on your deed or you transfer accounts to. So, technically speaking, any and all transfers, but there is a list of what the Medicaid caseworkers are kind of looking through to say, hey, wait a second, is this a transfer? Do we need to be concerned and ask more questions here?
Now, does the look back rule apply differently depending on whether someone needs nursing home care versus if they're using home based care?
So the two long-term care programs that I deal with, the nursing home program that you just referenced, which is the institutional care program, or the program for assisted living or at-home services via the home and community-based Medicaid program, they do not apply that look-back rule differently. Now, there are going to be some other Medicaid programs that actually don't have um, any type of a restriction on transfers. So when you look at somebody that's going to be applying for Medicaid, of course, if it's for the long term care programs, we are going to be looking at that look back rule. But for some of the other Medicaid programs that don't impose that program, then we can do transfers without any kind of a penalty. So it's important to know which program you're applying for when you're looking at any kind of planning.
What about paying a family member or a child to provide care at home? How does Medicaid view those types of payments?
So, under the rules, that's one of the things I just, kind of referenced a few minutes ago was the fact that the caseworkers are looking for potential transfers. And that's kind of one red flag they'll look at to say, hey, wait a second, was, a child being paid or grandchild? And they'll want more information if that is the case. Um, but if you can prove that it wasn't an uncompensated transfer, that in fact the individual was receiving services for those payments, then it's not uncompensated. They were getting something in return for that payment. They were getting caregiving services. We're going to document ours by using what we call as a personal care contract. And so we put an agreement in place signed by the caregiver child, usually the adult child, and the Medicaid recipient who's getting these services. And in that personal care contract, we're going to lay out what the services are that the caregiver, the adult child's being providing to their parents. We're going to put in that contract what the hourly rate is, and then we're going to multiply that by the Medicaid applicant's life expectancy, as stated in the Medicaid actuarial table. So we're going to come up with a lump sum figure that says, "Hey, look, as long as you're providing these services at this rate in this lump sum that we're paying that caregiver, and we have a signed contract, it's not uncompensated. We've documented it, and Medicaid's going to allow for that." And so we fully disclose that. We do provide that personal care contract
Mhm.
along with a statement that it's fair market value. Usually done by a care manager, a geriatric care manager, say, yes, this is fair market value that is documented in the contract, and Medicaid has not had an issue with that.
Mhm. And now there are so many what ifs in these situations, but
Mhm.
let's talk about an if that is pretty common where a grandparent is giving money to a grandchild for college or gifts over the years. Is that a problem? Could that come back as a violation at some point?
So technically, yes, if it's within that 5-year look back. But Medicaid's rule says that any kind of gift or uncompensated transfer, the presumption is they were doing that to become eligible for Medicaid.